Morning, everyone. I'm going to give you a brief overview and then we'll get started with the individual presentations here. This came about because so many of our veterans have experienced the passing of a family member that was a veteran, and there hadn't been significant planning done to take care of them. So the family members that were left were kind of left with the burden of trying to figure out how to take care of that veteran and all the benefits that they were entitled to. So that was the inception of putting this particular program together today. It's not meant to replace everything that's available on the VA website, but it's designed to get you thinking about some things. And we also have quite a few handouts that are on the table back where Steve Newton is sitting when you came in. If you didn't pick up those brochures that are back there, those will be beneficial to the discussion today. And then after you leave here, to be able to have a workbook to be able to collect all of the information that you should be collecting. And that's the way that we plan on helping you organize your affairs. So our first presenter this morning is going to be talking about the legal aspects of things, probably the 5 most important things that you should know in planning the legal aspect of your estate. And that's going to be Owen Oliver is going to do the presentation.
Do I need to, is this?
Yeah,
okay.
Both. And then this will advance the slide, the right arrow.
I have
If
slides.
you need, you just
Okay.
got one slide.
Okay. When I returned from Vietnam, 6 weeks out of the jungle, I was sitting in my first class at the University of Denver Law School. Quite a transition. But after graduating and passing the bar, I spent the next 50 years practicing law here in Jefferson County until I retired 1 year ago. But a big part of my practice had to do with estate planning. And so I'd like to touch on a couple of highlights that I think might be valuable to all of you. First, I want to take a little bit of a left turn and spend a couple of minutes talking about probate, because that could impact the documents that you really need in place for estate planning. I imagine a good handful of you have had some experience with going through a probate for friends, family, but I suspect that some of you have not. So let's touch on this. What is probate? Probate is the court proceeding that oversees the administration of a decedent's estate. Closer. Okay.
They're having a hard time hearing over there.
Sometimes probate is necessary, sometimes it's not. It doesn't have anything to do with whether or not you have a will. What typically forces a probate is the asset picture at the time of death. If you own any significant asset in your name alone, no beneficiary on that asset, no joint owner, there's going to be a probate. There's no other way to deal with the ownership of that asset except through court orders. That's probate. But what I've encountered over the years is there's a lot of misinformation out there about probate. And a lot of it has to do with the fact that probate systems differ sometimes significantly from state to state. There are good probate states, there are bad probate states. What are the bad probate states? It tends to be the community property states. Missouri, New Mexico, Arizona, California's terrible, Washington State, wherever the rest of the community property states are. I've had problems with some of the East Coast states. The last time I looked, a majority of the states, including Colorado, have enacted the Uniform Probate Code. Good law, good law. There are exceptions, but for the most part, probates in this state tend to be relatively fast, relatively inexpensive. I say relatively inexpensive. I mean, start to finish court costs, attorney's fees, you're probably looking at a few grand. And I don't mean to make light of that, but I've got to tell you that is so much better than the bad probate states where the cost will run 10 grand or a lot more and take forever to process. So the point I am trying to make here has to do with trusts. I've done a lot of trusts in my career, but because Colorado is a good probate state, it was not my practice to create a trust for a client to avoid probate. It is typically not really necessary in this state, and there are exceptions. So, if you don't have a trust, what do you need in place? First and foremost, obviously a will, a last will and testament. The last 10 or 20 years, I've lost track of the clients that would bring in to me wills they wanted to put in place, which of course they downloaded off the damned internet. I've got to tell you, I've seen a few that weren't bad. I've seen a lot more that to one degree or another were just flat dangerous. If you want to do your own documents to save attorney's fees, do your own contract, write your own promissory note, draft your own deed, whatever. In all those situations, if there's ever a problem with the language you've used, because of course, you're all wordsmiths and jailhouse lawyers and you think you know exactly how to word things. But if there ever is a problem with any of those documents, you've got the ultimate solution of getting in front of a judge and saying, Judge, when I wrote that, here's what I meant. You can't do that with a will. If you see a lawyer once in your life, have a lawyer write your will for you, in addition to the other documents. If the lawyer writes the will for you, well, and one other comment I should make is those of you in this room who may not have a will, you actually do have one. It's in the Colorado statutes. The Colorado law says if someone in this state dies without a will, here's where all your assets go. And it can get tricky if there's a surviving parent. It can get very tricky if there's a blended household, adopted kids, whatever. It's a pretty rare person who I think would be satisfied with the statutory will that's automatically in place for you if you don't have a regular will. So, last will and testament is critical. If you want, you can have the attorney put a provision in there that allows you to use a separate document. It's got a fancy title, Memorandum for Disposition of Tangible Personal Property. But if you have that document, you fill that out yourself, in addition to executing the will. You want to leave antiques to a friend, or jewelry to a niece, or your 65 Mustang to a brother, or tools to a cousin, whatever. You fill it out on your own, doesn't even need to be notarized or witnessed, and you're in control of that document. What other documents do you need? Obviously, powers of attorney. A general durable power of attorney, where you name someone who can handle financial matters for you if you are not able to for any reason. A medical durable power of attorney, where you name someone who can make medical decisions for you if for any reason you're not able to. The medical power of attorney, deals with approving medication, consent to surgery, whatever. One thing a medical power of attorney does not do and cannot do is give that person, the agent, the authority to pull the plug on you. That's called murder. Which is why you may well need the last document, the living will or medical directive. The living will takes a lot of different forms. There's a lot of different versions out there. But the heart of it is typically a provision where you indicate that you do not want to be kept artificially alive on a machine. Those documents, it's a fairly simple, straightforward package. Everybody needs it. Everybody needs a will. One reason you need a will, even if you say, oh, I'll just let the statute take care of the disposition of my assets, is a will is the only way that you can name a executor to be in charge of things, or what's now called, the modern phrase is personal representative. And it's just common sense that you should direct who it is that you want to be in charge of things to handle disposition of assets, any legal issues, whatever, when you're gone. I've actually got a couple of cards if anybody's interested in referrals in the area, a couple of local attorneys I've dealt with, be glad to hand those out. But that is the basic package you need. One last comment on trust. I've lost track over the years how many times I've had a client say, but Owen, I talked to my cousin and she says that I've got to put all my assets in trust to avoid probate. At which point I turn to the client and say, oh, where in California does your cousin live? Well, how did you know my cousin's in California? Well, because that's California. And what I've seen over the years is California being California, they think what's good for California is good for everybody. And these seminars spread across the country, whatever. I'd be surprised if a few people in this room don't have those 3-ring binders that has been created for you by going to one of these seminars by attorneys. There's some validity to it, but in many cases, I think it's overkill. So I think the documents I've just described are the documents that almost everybody in this room needs in place. If you don't have them, please contact an attorney. There's hundreds of attorneys around who do this. In my experience, most of them are very good, and I'd be glad to direct you to a couple that I personally know if you like. I don't think in the course of this we have time for questions while we're going on, but I'll certainly be here after the meeting. I'll make myself available. If any of you have particular questions, be glad to talk to you. Thank you.
Hey, Owen.